Thank you for having me.
Yeah. Good evening, everyone, and a warm welcome to Daksha series, our endeavor to throw light on topics of contemporary interest in a focused and thematic manner. In this inaugural edition, we focus on the theme of data, risks, and rights, a matter of great interest to lawyers and policymakers. I am Ananth Padmanabhan, Dean at Daksha Fellowship, India's first fellowship for lawyers with specialization in three different pathways: technology, law and policy, law and regulation, and disputes resolution. We are grateful to Lok Sabha for partnering with us and promoting the cause of legal education. Now let me welcome our speaker for today, Malavika Raghavan. Malavika is a lawyer working on emerging issues for policy and regulation at the intersection of technology, finance, and inclusion. She heads the Future of Finance initiative at Dvara Research, focusing on challenges for regulation on consumer protection, financial inclusion, and stability in India given the rapid digitization of financial services. Malavika is a 2018 Fellow of the prestigious Chevening Financial Services Fellowship at King's College London and a 2016 Fellow of the On Purpose Social Enterprise Leadership Program. She is also a member of the Asian Privacy Scholars Network and a member of the steering committee of the Data Governance Network in India. She has graduated with an MPhil in public policy from the University of Cambridge and completed a 5-year undergrad law degree at the National Academy of Legal Studies and Research, Nalsar, Hyderabad. Today, Malavika will be addressing us on the fundamentals of data protection, why it exists, what does it entail, and how does it operate at a conceptual level. Before we begin this session, let me remind you all that all participants in this session are on mute. But you may post your questions and queries in the Q&A tab, and we'll take them up both during and at the end of the session. With that, over to you, Malavika, to begin this masterclass. Thank you.
Thank you, Ananth, for having me. And I'm really pleased to support the Daksha Fellowship as well. I think it's a very important kind of additional shot in the arm for, I think, executive education in India, especially for kind of mid-careers lawyers, because we need more of you in the space, especially thinking not just, after the fact when the laws have been passed, but also how can we think meaningfully about policy itself. And on that note, I think what I'm kind of doing in this session is primarily framing for you a little bit some of the basic kind of conceptual underpinnings of data protection law per se. It is a deep and sort of quite a wide field. So my attempt in this session will be to give you in the first part an overview of where we are and why this question is important. And then in the second part of the session, I was actually hoping to do a bit of a deep dive using the actual law that we have now, which has been introduced into Parliament, currently before a joint parliamentary committee, and we expect it to come back actually and potentially even have a law in the next 12 to 18 months. So it's an exciting field to be involved with. What I'm going to do is try and share my screen with all of you so that you can see what I'm seeing. And before I do that, I'm going to ensure that I don't have any technology failures, as always is the case. So let's see if we can get this to work. All right. So can you see my screen okay?
Yeah.
Great. Okay. So as I said, this conversation today, we have about an hour, 45 minutes. So essentially what I'm going to do is spend the first sort of 20 minutes or so going over 1 and 2. 1 is pretty much for those of you, if I think there are quite a few of you online, so if you're here, hopefully you don't need much convincing, but given how early India is about thinking seriously on questions of privacy and data protection, I always find it useful to think about what should be our underlying jurisdictional and jurisprudential approach to this. Should that remain within the boundaries of India? How closely should we think about overlaps with other legal regimes and so on? And then into concepts and protection. Then we'll take a short break. Hopefully we can do some Q&A then. And then jump a little bit into the data protection bill itself. I was actually hoping to show you the kind of bare text of the bill and use that for a very high level conversation about broadly the structure, core definitions, and of course, rights and user protection, which I care quite a bit about. So let's jump straight in. Why care about data protection? Why are so many countries passing data protection law? I find this a really helpful graphic to think about the scale of what's going on and this unique moment where we are all part of a legal community that's pretty much making up a new legal regime. So that's, I think, the opportunity of being a lawyer at this point of time, but also, to be honest, for being an economist, an anthropologist, any kind of multidisciplinary thinking is really important, because I definitely think we're in a foundational moment where we're learning to think about a new way of understanding something in society. And potentially the last time we thought about this is when books started getting printed, and we needed to think about how do we protect intellectual property in an intangible form. So this is, I think, almost that foundational. This is an important slide because you see in the last decade, there has been a veritable explosion of data protection laws. I would say India is probably the outlier for not having a law like the US. There are some, one or two large economies in the world or countries who haven't yet passed a full spectrum law, omnibus law, but obviously we are very close to it, and there are rumbles of that in the US as well. And much of this is useful because if you think about the 70s on this slide, that's really when data protection laws started becoming important. And kind of why is that the case? I think it's useful to think about this vis-a-vis the development of newer technologies that are enabling the processing of data. And I think that's as our society learns to think about how do we enable this while limiting kind of harms? How do we harness the benefits while limiting the harms to ourselves? Because ultimately the law is here in service of that citizen-state contract. And how do we ensure that people are able to get the best of these information processing technologies without being exposed to some of the harms? And I think as computers have developed and larger scale information processing has developed, clearly you can see there in the last decade this explosion. I then wanted to think about why then privacy. So we've gone there from information, processing about human beings, which is the fundamental preoccupation of all data protection laws. Why then do we need to think about privacy? Because privacy in some sense is a concept that is quite separate from data processing per se. There are arguments that people have always processed data about other human beings. That when we move into a new town, we go and have a look at who our neighbors are. These days we are on Facebook, obviously. But why does data protection intersect with privacy? And I think the first foundational concept I wanted to talk about is the difference between these two terms. On the one hand, data protection is about some processes, procedures, governance, accountability frameworks when you're passing around personal information, because personal information and the rules around that and how to manage it are very much the heart of data protection law. But privacy is a different concept because privacy is something personal. It's about what do you and I want to keep private? And they intersect really as information flows and personal information flows often become much more mainstream in our society. So previously, information and personal information about ourselves is something that we had a lot of control about how we shared. I think in a digital and digitizing world, it's not merely that a computer is a new type of technology or a new type of quantum computing is going to change everything fundamentally. The thing it does do is make us less of an agent when it comes to representations of ourselves and our own personal information. So in the past, you could choose whether you told your friend something about your past or not, depending on how much you trusted them. Surely how much you shared with your family was different from how much you shared with a kind of loose friend that you'd met maybe 2 or 3 days ago, or someone that perhaps you were considering a romantic relationship with. So obviously all of this, just to put it in your mind, are graded information sharing that we are continuing to undertake in our everyday lives. And informational privacy at the heart of that is this definition, which I took from an article that I've linked to, and I will share all the links after the lecture. It's really an interest in preventing information about yourself from being collected at one level and controlling how others can legitimately access it. And I don't need to spend too much time on this, but I think it's quite fundamental because that intersection between privacy and data protection really comes from the fact that more and more we have very little control over who's collecting information about us and how that is shared, who has access to it. And really, I think informational privacy as such is just a movement to think about how do we put the individual and their interests at the heart of a data protection framework where we are talking about how data is managed. So I hope that was clear, but we'll have time for questions. Just to go back to what I was saying about jurisprudential basis for this, right? So on the one hand, you want to set up a framework for how data flows, especially personal data in a very digital world. On the other hand, you have these imperatives of privacy and graded information disclosure to maintain trust between human beings, between institutions in our society. And so what are the motivations? What has the law got to do with this in some sense? If we built our information architecture as well, and we all sort of came to a view on how we wanted information to be shared, surely what is the need for a full law about it? There is an argument that existing laws could just be extended to deal with some of these issues. But I think at the very heart of it, the Puttaswamy case and what we've been through, what all of you have probably been through with the Aadhaar project, especially in India, brought about the need, it really surfaced the needs for a legal motivations jurisprudentially for a data protection regime based on two things. One of which we were just talking about, which is when you have these individual imperatives or kind of entitlements or interests of an individual that are surfaced as being harmed, perhaps say when there is a large data breach and somebody gets to know all of your personal details, which you did not intend to disclose, then what is the state's role there, both negative and positive, in order to preserve you, your agency, and ensure that just because somebody got to know your health status yesterday from a breach does not mean that you are kept out of employment, right, for instance. So how is information and your privacy maintained to preserve agency, but how are you protected from harms? And a lot of what we're going to talk about in the next sort of 30 minutes is going to be around this idea of what is a fundamental right to privacy, what is the role of a data protection regime in ensuring that those privacy rights are protected, and where should a law stand? On the other side of this is the second part of that slide, right? The competing framing and the competing interests of a digital economy. So I think a data protection law per se always has been, anywhere in the world in the history of data protection, has been slightly embattled, because it's not only core focused on optimizing for ensuring an individual's agency, autonomy, and privacy, though that is often the primary aim of a data protection law, to ensure that personal information is used in a way, and the rules say they are used in a way that secure a human being's agency, privacy, autonomy, respect. The second part of it is we also want data to flow in our digital economy. All of us are able to have this webinar because all of our personal information is sort of swishing around in the internet. And how do we ensure that that kind of free and fair economy, digital flows can continue, so that Ananth, where he is, and I where I am, and all of you can actually have this kind of knowledge exchange, but do that in a way that is not exploitative, that does not result in untoward sort of impacts, whether that is, what we've seen, say, with the Cambridge Analytica case, affecting entire democratic processes. And that's when, this kind of flow can go completely wrong. So how do we have a free and fair digital economy as well? So this is kind of why I hope I've convinced you in the last sort of 7 or 8 minutes why data protection laws are important, because they are trying to balance these twin imperatives, sometimes more, about how to protect individuals and their need to maintain trust as a society by maintaining privacy, with the need to share personal data about that person in order to provide, say, a service or for some other means. And really think about how can the law upfront help us as a country negotiate a set of rules that we are all okay with. Because in some sense, can we all, just to go back to my previous slide, come up with a set of rules that really respect how information about you and I are shared with somebody else in a way that is legitimate, given that we are living in a world where our personal information often travels much longer, much faster, and much wider than we actually often do. And the next part of the lecture, that's the kind of first part of it. The next part of it, I really wanted to deep dive into concepts and principles in data protection. And in order to do that, I'm going to spend, again, as I said, this is a very, very sort of deep and wide topic, but I thought we could spend a little bit of time just talking about the history of the core principles of data protection, because even though some of this is very foundational and still being understood as a society as we evolve, there is on the plus side, global consensus, at least around what aspects of data flows should we be thinking about managing. And to do that, I'm going to take you first through some first generation principles, as we like to call them in a sort of data protection law, as well as second generation principles. And then I think where we are currently is almost like a third generation of data protection laws currently. Now, what do I mean by first generation principles? We talked earlier about 1970s when all of the data protection laws really kicked off around the world. And something here which from a legal perspective is really important, these documents, I've just put them there, are legal instruments that I think any lawyer working in data protection, it will be good for you to have a look at. In 73, interestingly, it was a health issue that created the initial set of fair information practice principles in the US, where there was an excellent committee set up to think about what happens when computers start to process large amounts of personal information without the person knowing. And that came up with a set of 7 or 8 core principles, which form the basis for what we're going to talk about in this part of the lecture. They had interestingly, there's no cited evidence of their influence on the 1980 OECD privacy guidelines, principles that we talk about quite widely in the privacy community. But they do have a lot of resemblance. And again, we'll come to it. I'm not going to use this lecture to kind of take you through each of these documents, but I'm going to abstract to a higher level and tell you the core of what they say. But essentially from these documents, as well as the Council of Europe's Convention 108 and the APEC framework, which was later on in Asia Pacific region, we came to an understanding of about 7 or 8 high-level principles. When should you collect data? How should you treat it? How should you use it, disclose it? What kinds of security should it have? What kinds of rights should users have in relation to their own information, whether to use it, to know whether you have it or not, and so on. And lastly, what kinds of mechanisms and institutional frameworks do we need to ensure that these rules are followed? That was the first generation. The second generation really came with the EU Data Protection Directive. Oh, I think my slide isn't showing. There should be a little bit down there, but that's fine. We can still talk about this. The second generation of data protection principles really arrived around the 90s. And this was when the EU set up a data protection directive. You had an additional protocol to the COE 108. And a whole set of other regions outside of Europe also started thinking about their data protection laws, as obviously the tech boom was happening. And then the last and third generation is really something that I'm quite excited about, because I think India is really going to contribute to this thinking in a significant way and challenge a lot of existing thinking, but also take on some of the thinking that we have unfortunately or failed to do until this point of time. And that really comes with this term you might have heard, GDPR, right? The General Data Protection Regulation, but also a host of laws that are being passed in other countries. Brazil, for instance, has just had a data protection law passed. South Africa has had a data protection law passed. The US is considering passing a data protection law. So all of us on this webinar or lecture are very much part of that third wave, as it were, and that's something to be excited about. What has all this taught us, the first, second, and the emerging third wave of data protection? As I said, given the paucity of time, we're not going to be able to go through each of those instruments. But what I'm placing before you is really a very high-level framework that I hope will help us talk about some of these general principles. And I'm just going to also let Ananth know, this is a very deep and wide topic, so feel free to come in and keep me for time, Ananth, if you feel that we need to get on to the Indian law, because I'm quite keen to keep that section as well. But I'm hoping to spend, again, the next maybe 10, 15 minutes just quickly rattling through this, if that's okay. I will continue then. So interestingly, over here, when we're talking about concepts, what do all of these instruments plus our own existing laws and all of the countries we've talked about tell us? At the highest level, I think there are some general principles that develop around when is it fair and reasonable to process information. These have different terminologies in different countries. Some people call them legitimate purposes. Some in our own law, which is forthcoming, which we'll talk about next, we call it fair and reasonable processing. Other countries say that you should have a minimum standard of data quality when you're processing. I think at the heart of it, to kind of grossly oversimplify, I think that the thing to keep in mind is that we must ensure that when we are using another human being's personal information that represents them and is often being accessed with a view to make a decision about them, whether they get a job, whether they have an infectious disease like COVID-19, whether a court case should go in their favor or not, we must have a general basis in sort of almost administrative law principles where you are being fair and legitimate in that access, and you're not abusing the trust that you are in a position that you can abuse because the person often doesn't know or may not be aware that you're accessing their information. So that's just these sort of general principles that I would like to flag. In our own law, like I said, we'll be talking about fair and reasonable processing. But when you get into the heart of it, more very clear principles that we have are principles around collection. So the second bucket, and often thought of as the first bucket of principles, is collection principles, which are then mandated through rules in the law, which tell you when you can collect information. And normally that is when you have a specific purpose to collect that information. So this is one of the most foundational aspects of data protection, and a big shift, because it tells you that any information, just because you have a device on which you can capture it, does not mean that you should capture it. You need to capture information for a specified purpose. And that purpose you need to set out upfront. For instance, Daksha might have said when you signed up to this, we are collecting your email and so on and so forth, maybe your phone number, in order to help you join this webinar. Daksha generally should be under an obligation to not then abuse that for anything that's completely disconnected from this fellowship itself. Sorry to put you under the cosh, Ananth and everybody else on the Daksha team. But say, for instance, they were using your information to then sell it to a set of people who are building lists about employable candidates in the law. You might be okay with that, but you might not want other people to know, maybe in your current organization, that you're looking for a job. So there's the kind of line in the sand in terms of purpose limitation. So purpose limitation is a principle around when can you collect information. The other one itself is to say that the means of collection itself should be lawful and fair. This is where we get obligations around giving you notice. You should be told that your information is being collected. And once it's collected, you cannot, by intrigue, try and get that information of another person. And it should not be done in a way that's intrusive and sort of overriding your privacy rights. There's a lot more we could say here, but I'm going to swiftly move on just because in interests of time. We then go into the third sort of bucket. And this is somewhere connected. So in the collection bucket, what we've talked about is that data needs to be collected only with a view to a specific purpose. The means need to be lawful, and you generally should be giving someone notice that you're collecting it and also taking consent from them, though this is a very embattled concept that perhaps we can talk about when we're discussing the PDP bill as well. And then what we are saying that once you have collected the information, we need some rules around the use and disclosure of that information. And that's how we're moving from bucket 2 to 3. So here again, all of those laws that we were talking about, international instruments, national laws, have come up with certain types of rules that you would look to see in a law when you are thinking about what are the use and disclosure regulations here. To give you an example of this, generally, the use of a personal data must be in line with the specified purpose that you said when you were collecting the information. So to use our example again, if Daksha and the team were extracting your information and using it for something totally different that you are not okay for, that is a contravention of the use principles that we would say to use it in line with your specified purpose. The other thing is around, often countries have rules around when can you use this for a secondary purpose. Now, it might be, like in our previous example, that you do want to be included when Daksha is letting employers know that we have these candidates who are interested in further learning perhaps, or want new opportunities. In that case, what are the rules around that? Should people at Daksha come back and ask you, are you okay to have your data shared? Can we use it in order to introduce you to third parties and so on? So that, in that case, is a kind of secondary use set of rules around that. And then often, what about new uses that are not related at all to this? It might be something completely different, which has nothing to do with the context of learning, the context of a webinar, and so on and so forth. Say, for instance, they want to sell you something that is, or somebody, a third party wants to sell you something and they just simply want your information for that. In that new use case, what should be the rules about how that data is handled? Should you even be told, or can they just go ahead and use it for something else? And then, of course, when are there any exceptions to around notice and consent and so on? So we're about halfway through. As I said, again, these are very, very high level kind of concepts, but we'll have time for questions in about 5 minutes. We're then moving into the fourth bucket, which I've called here security principles. These are all the principles around security safeguards. Generally, if you're collecting a large set of personal information about people, you need to ensure that you have adequate data security. And if their information is breached, then you may generally have rules around what are the breach notification procedures. Should people be told? Even if you're not telling an individual, should you tell some authority that, say, for instance, all the health data in the country has been hacked, or all the financial information in a bank has been hacked? Unfortunately, it's very stressful when you think about these things, but what are the processes and procedures you have in place if something like this happens? And what are the proactive security measures that are mandated by the law to ensure that it doesn't happen? So, A, to prevent a breach or unauthorized access or an insider attack or misuse of that personal information. And then B, of course, what to do if it unfortunately does happen. So that broadly are the kinds of security principles and concepts that data protection laws will deal with. And then we go on to a kind of section which is, I think, highly embattled and close to my heart, but this idea of rights for users. So ultimately, you are the subject of a data protection law, right? It exists because it is there to protect your personal data, ostensibly. In such a case, how should we think about what rights individuals should have? So this is there's a variable set of rights across countries. To give you something that we normally see in data protection laws would be the right of access. So and confirmation that someone indeed has your data. Because data collection is so ubiquitous, you might have walked into a store and they might have, in a futuristic scenario, captured your face, and maybe they have a facial recognition software that twins you to a database, which then says, this person is actually like a platinum member of XYZ. This is their credit score, so on and so forth. Some countries already have these schemes. In that situation, should you have a right to know that that's happening? Should you choose to ask? And so on and so forth. So these are all rights around an access, confirmation that indeed somebody is holding your data. In an emerging right is the right for your information when held with some person to be transferred to another person or another entity. So say, for instance, you're locked into a service and you want to access another service. And you just want them to give all the information. So say you have a bank account and you want to open another bank account with another bank. Do you really want to go through the entire process of telling them that you're creditworthy, that you should have an account, that you should have the service, or can a bank just share that information directly? And then there are rights around deleting your information, perhaps anonymization, emerging rights like the right to be forgotten, which we will hopefully talk about as well. And then the right to withdraw your consent, for instance, from data processing. So you may have said to Daksha, yes, please have my information and give it to anybody who wants to sell anything to me or any other service. And then maybe a year later, there are just too many calls and you want to say to Daksha, please just take me off your database. You should have that right, essentially. And at least clearly I've told you what I think. Some countries agree and some countries don't. And we'll see where India lands. And that actually swiftly takes us to our last kind of category. Now, this is kind of my equivalent of a miscellaneous category. Because I think over here, there's increasing recognition of several types of laws and countries that there are certain types of data processing which need a higher level of rules than everybody else. So maybe it's because of the people whose data is being processed or the types of techniques that are being used to process the data. So to give you an example, there's almost universally, there are rules around sensitive data. And different countries have a different idea of what is sensitive based on their cultural context. For instance, in Europe, after the fall of the Iron Curtain, you see membership in a trade union as being sensitive information in certain countries, right? First time I saw that, I thought, why would that be relevant? But obviously, then you think about the history and context there. and what membership in a kind of union organization meant, and what happened after the kind of fall of communist regimes, for instance, is something to think about. Of course, race, caste, gender, these are all often considered most sensitive. Often you also have more special rules around sort of children. How do you handle children's data? Is that more sensitive, less sensitive than everyone else? Different countries have different views. And increasingly, as we move into this big data world, I think that was a great talk yesterday for those of you who joined the conversation, which Usha Ramanathan had with Prerna Mukherjee and Mahesh Menon, is just what happens when your data is being automatically processed, and should you have any specific rules around when there's no human on the loop and there's just an algorithm which is making decisions about you, and choosing to use your data in ways that maybe a human doesn't understand, where it's using proxies in order to make decisions about you, which may signal certain characteristics about yours that you want to keep private. Should we have a new legal framework around that? In the US, again, there are special categories, say, against certain types of data use. For instance, direct marketing protections, where people get spammed. They've had data laws to pass to say you cannot spam people, or cannot or can spam people. So that's just kind of in the last bucket. In this section, hopefully in the last sort of 20, 25 minutes, what we've done, just to recap, is we've started to think about what are the bases to protect, to have legislation really, to protect data, personal data, and why informational privacy is a central objective there of these legislations, but also the need often to enable a flow of information without harming the privacy of individuals. We've then gone into a broad sense to try and understand what has been globally the history, and these are some of the concepts that we've come across. I wanted to quickly, before we go into the next section, just also tell you this has been a kind of historical view across the globe, because ultimately, even in India, our conversation now legally is about these principles. But we've had a very interesting developments in our own law. Obviously, everybody talks about the fact that we are getting a new data protection law. It does not mean that we do not have data protection at all in India currently. I just wanted to spend a few minutes thinking about the Indian development and our relationship to data protection and privacy. It's a very interesting conversation. And again, we've had multiple of these over these weeks, but I think at the highest level, I do think that there's a lot of interesting writing now coming up around the Constitutional Assembly debates, and why we chose not to say the word privacy, for instance, in the Constitution, even though there was some consideration. Interestingly, Rahul Martin's Privacy 3.0 book does have a small section on this that I recommend. So also the role of B.N. Rao, for instance, in all of this was very interesting, I think, as a person in the Constituent Assembly debates. But I mean, in India, ever since sort of the earliest days, I've put some case law over here, but I've not gone into the absolute kind of early days. But ever since the 50s, we've obviously been having cases in India where we have thought about police dissension, privacy, and so on and so forth. Some recent sort of third wave style case law has also been around information, and not just privacy in the context of bodily information. Can you search my house at night? But information itself, and their, information, personal information on phone, personal information from health data records, personal information on financial records, and of course biometrics in the Aadhaar case. All of these have evolved a kind of patchwork of protections that deal with some of these principles. When can you collect? How should you use? What's the security? What are your rights? But ultimately, and this is the real blockbuster of privacy law in India, it's obviously the Puttaswamy 1 judgment, as we like to call it in the privacy community. Really a judgment that placed informational privacy and data protection at the heart of the Indian Constitution, and gave us a very strong jurisprudential basis from which to build out a data protection law. I'm of the opinion that you no longer can talk about personal data as property in India, because it's now a fundamental right. So it really has very strong human rights and personal autonomy moorings, which you may not always say. You can't really talk about a personal information being bought and sold the way you can a pen or a house or a piece of land, even though that is an analogy that often comes up. And so that's kind of where we're poised. We have this nice platform developing in India, and Puttaswamy has really given us basis from which to build a law that might cover a lot of these sort of timeless core principles of data protection that have developed. But at this stage, I will pause because that was the plan. And before we go into the data protection law in India itself, maybe we can have some questions. What do you say, Ananth?
Yeah, sure. Malavika, I mean, I think this has been very, very insightful, and you've really taken us through the core principles of data protection. And yes, we do have quite a few questions here, so I will just help you navigate it. The first is by an anonymous attendee who has a concern, and he says, while jumping from one social website to another, let's say Instagram to Facebook to Tumblr to Snapchat, one finds the same kinds of advertisements of products you might have checked out on, let's say, Amazon. So what is really going on here? How does data flow happen? And is this, is this some conduct on which we can hold platforms liable?
So if I had to paraphrase that question, is that, sorry, I'm just going to stop share for a minute. Yeah. So is the question really because of the lack of visibility of data, of how your data is even being captured or how it's flowing?
I think the attendee wants to know, how do you sort of find out in the first place whether there is unauthorized data sharing, and then of course agitating for the remedies.
Yeah. So I think that's a really great question because it surfaces some of the anxieties that we're often told don't exist in Indian society, right? Like actually most of us, several of us, whether irrespective of how wealthy we are, I think do really worry sometimes because we just don't know. I don't know. I mean, I spend my time reading this stuff and I don't know how many cookies are in the background. I think the response here is, one is obviously we can think about rights, about how do you get to know, disclosure, cookie consents and so on. But I think the deeper conversation is that should you know? I mean, do you need to know how a car works in order to drive it? Or should you just have, should you just at the deepest level know that somebody is making some quality checks so that your car doesn't go up in flames when you start the engine? In effect, I think that's kind of what's happening with data. In the absence of a kind of sensible framework, everybody is just using what they think is the best thing to do. And so we are in a position where we're quite vulnerable as citizens. I think if we have a law which says this is how Amazon should hand off to Facebook, should hand off to X third-party website, and that's just on the web, then it shouldn't be our problem. It should really be the law should help us come up with a set of rules where that level of sanity check and security is provided, irrespective of whether we know about it or not. I don't know if that's a helpful answer.
Sure, I think that's quite helpful. Suneet Puri has an interesting question. Currently, tech users are required to agree to the TNC of a certain website, etc. One hardly ever reads those, right? So how does one navigate such wrap contracts? I think this goes to the sense of consent fatigue in people. So that's really the question. So what are your thoughts?
Yeah, so it's great. I was actually wondering, I didn't spend too much time on consent when we were talking about collection principles, just because I knew it is always a topic of conversation. And so, yeah, I think it's something that has to be addressed. So at the heart of data protection law is this idea that we are sharing data in exchange for services. So it's an equal contract, like any other contractual relationship. So like in any contract, I say to you, I'm going to sell you this for 10 rupees. And you say, whether you've written it down or not, implied contracting rules, which many of you no doubt know, will just say yes, consideration, and then you've made the transaction and it's complete, right? So in the same way in data protection, we think, oh, here's rules telling you that I'm going to collect all the information about you, your family, your unborn children, and then you say yes, and then you use the service, and so it's an equal contract. And that saying yes at that point of time is actually consensus ad idem or consent. And I think what a lot of people in the first, second, and third generation of data protection law are arguing for is that that's an absolutely ridiculous construct because there is no consensus ad idem. It's not even, I mean, you don't even have to prove whether it's an unconscionable contract or your data is used badly. The fact that, there is no hope unless you had like a PhD in big data analytics or whatever, that you will ever understand these terms and all possible uses, that consent is meaningless. So this is increasingly something that the idea of a notice and consent framework is being broken down. I think the difficulty we often have is then the so what of it, right? And that's why we have this kind of situation where we continuously keep asking for consent, even though most thinkers on this topic know that it's pointless. is that we are at the stage of thinking like what else would work. And there are a few interesting models out there. My own preference is for this model where we put accountability on providers to certify that they are using, certify or have a test, have an objective test, which says that they are using matching use to a purpose. That's something that can be done without the user there, but the user should have notice. You should be told that something's happening. You don't need a 100-page contract. So that if you choose to react, you do. But in any case, there should be back-end laws which are testing if use is proportionate to purpose. And then you have a regulatory apparatus that checks that. And honestly, it doesn't have to be expensive, doesn't have to be a huge state capacity issue. You could write code to ensure and to audit if something is being used according to what they say it's being used every time a program is executed. And I think there are many creative ways of doing this in a kind of way that even works for our country. So yeah, the short answer is yes, consent is pointless, but we're stuck with it. And the long answer is maybe we should come up with a regulatory model that doesn't make it the user's problem to consent or not consent, because it is meaningless.
I've got 3 questions here on health data. If you don't mind, I can club it all together. And if you, of course, forget anything, I can later remind you. So the first is Shefali Malhotra raises a question on contact tracing and says that while there's a lot of talk on data protection, now we are saying near universal acceptance of mass testing. So to you, like, doesn't this raise concerns of data protection and privacy? And is there a public interest overriding it, and therefore, this is all acceptable? The second question is the usage of health data by an employer, right? Is that violative of principles of fair and reasonable use? And the third question is the digital healthcare industry itself. How do you see data breaches affecting the industry, and what are the kinds of harms that can arise on account of a breach?
Was the second question on health data and I didn't get the second part?
On the employer, like how employers can use health data and whether that violates principles of fair and reasonable use.
Yeah, great questions. Wow. I mean, honestly, I think we can just leave the next lecture to deal with the PDP bill at this rate. But
yeah, we are getting some great questions.
Okay, so on contact tracing, it's interesting that I've actually kind of spoken to a few people about contact tracing, even though my intention at the start of all this was to studiously avoid all debates about contact tracing, because I thought it was a distraction. But yeah, apparently, it's a serious public health response in our country. So my sense is with contact tracing, there is an argument to say that we could use technology to measure the spread of this disease. And I think that's quite a valid argument. At the highest level, I think that argument has been challenged at a kind of just at a substantive level by people who say that unless you have perfect, really good information about the health status of a person, it's pointless to go down the contact tracing route. Because unless you know that someone is definitely infected, you get all these kinds of false positive, false negative results, which could actually create problems for contact tracing. So if you have bad data, you have bad insights. That's not really a privacy concern, though. That's just a data quality concern, which is more a data protection concern. And also, I think the other thing that we've noticed a lot of people say, and we have as well, that in a country like India, it's really hard to do contact tracing through an app because majority of our population is on feature phones. Question of if you need 60% saturation for contact tracing to work, will it ever really take off in India now? So that's kind of, look, with privacy, I think there is always a sense of how are you accommodating individual and public interests. But I do think that often it's not a trade-off. I think most of the time, privacy is a little bit like any other right? Speech, for instance, or it really comes down to how much is your society committed to that right. And if our society says we don't care about rights, that's a broader comment on our society, right? You can choose, do you want people to be free or do you want people to be in chains? And then you build your laws accordingly. So I think you just got to commit to the rights. Sorry, I'm in a bit of a kind of privacy-friendly mood. But yeah, I think so on contact tracing, I think you can do contact tracing probably well. Is it going to work? I think there are questions on contact tracing. On data breaches, that's quite I think that's well-known territory now globally as well. There's an excellent paper on the theory of data harms by Solov and Citron, Daniel Solov and Danielle Citron, that I often think is great. And again, I think there's another Ryan Callow paper perhaps on typology of data harms or something like that. But I think broadly, there are 2 points here. One is there are immediate harms that come from a data breach. That is where your subjective privacy is breached, in that you maybe shared very sensitive health data with your hospital, and suddenly it's out there and everybody knows that you have, say, a communicable disease or a highly contagious virus, and that has several consequences. So that's just an immediate breach that comes from the loss of the data. There are then second level harms that come when it's used, and this is tied to the other question, when it's used adversely against you. So if you're very lucky, no one knows, there's just so much data out there anyway, nothing goes bad. In that situation, you've had a privacy harm, but you may not have had any other harm. In most cases, when there's rich financial data or rich health data out there, there's a high possibility that it may be used at some point adversely against you. And in that case, you have second level harms. And yeah, obviously, like your employer might choose not to employ you if they realize that, say, you have advanced stage of cancer, perhaps, or you're pregnant, or any one of these many things that people often face, or a disability that people, has nothing to do with your job. But people face discrimination on those bases. I think the most interesting, and this is where I'll kind of close this comment, is this question of, is risk of harm a harm? In data protection. So say you've been breached, your data is out there, and say, let's take a situation, say you're HIV positive and your data is out there, and it's not clear to you that your employer knows or anybody knows in your community you're taking all the right precautions. In that situation, is the risk that you might be harmed in the future itself a harm? The fear that you live with every morning when you wake up, is that a harm? So these are all the kind of, I think, broad ideas. But yeah, there's a primary harm from the breach and then a secondary harm from adverse use of data against you.
Thank you, Malavika. There are quite a few questions on remedies for data loss and data breach. To all of them, my response is learning happens one step at a time. And we have one more masterclass tomorrow by Neha Chaudhary of Ikigai. And she will be addressing some of the issues on compliance and penalties and the remedies, of course, that come under that. So do sign up for that webinar as well. And my colleague Hemant is helping you get the registration link. All of you who are sharing your email ID here, we'll just help you with that. So with that, Malavika, I think we can proceed to the next leg of your masterclass. Sorry, you're on mute.
Classic tech fails from somebody who's talking about technology law. I'm just wondering what's the best way to do this, because I think we have about 10 minutes left.
Sure.
So what I'll do is I'll maybe spend like a couple of minutes telling you where we are, and then actually I thought it'd be a nice opportunity. Maybe it's push the burden on Neha for tomorrow's class. Is kind of, I can just show you the structure of the bill, so we can have a look at the bill itself, which is quite interesting because it's always exciting to look at draft legislation, and maybe just pick up on a couple of things like definitions. I don't know, and we can look at rights, but I think, and exemptions I was hoping to do, but maybe I'll leave off the exemptions for now because there's definitely no time.
So Malavika, there is a pretty patient audience. So if you have some grace time, we can continue for another 15, 20 minutes. It's absolutely fine. Depending on your time, I mean, because
sure.
I don't know.
Yeah. Okay, yeah. So let's do this and then let's see where we go.
Sure.
Yeah,
sure.
And then I have a hard stop about 7:15 because I have a call afterwards.
Sure.
Yeah.
Sure. That's fine.
So I've just gone back. This is kind of pretty much the last substantive slide, and it's not very substantive, but so like I said, right, I mean, we do have in India already a basis for a data protection law, and Puttaswamy, they specifically referred to the fact that there was this committee established with Justice Sri Krishna as its chair, who you've also had the pleasure of listening to, given the great curation by the Daksha team, who are thinking about the framework law. What did that result in? We got actually a draft law sometime in 2018 at the end of the committee's process. Following that, there was some further consultation by government, by the ministry, which is MeitY, Electronics Information Technology, and then it went into further consultation internally in government. And then in December, suddenly one morning it was introduced in Parliament, a new form of the law, of the data protection law itself. But before we get there, I think one thing I wanted to take pause and kind of take stock of where we are currently, because until that law comes, which could be next month, it could be many more months or maybe even years. I think what we are currently operating under is the closest thing to data protection law that we have in India is the IT Act. So for those of you who are thinking about where do we find any of those general principles, this is the closest thing we have to a law. It comes under the Information Technology Act of 2000, and in 2008, this act was amended to put in place a single section, which you will hear, I'm sure many of you know, it's called 43A, which talked about the need to have reasonable security practices and procedures, especially when dealing with sensitive personal data. And that provision basically said that government or a body can make rules for reasonable security practices and procedures. Following that, for about a few years, nothing happened. And then we got the 2011 RSPP rules, as we like to call them. So this is where you would want to go. They have a few provisions. If you want to know about where data protection currently stands, there are many weaknesses with these rules. They've been contested on substantive grounds, saying that you were given powers actually to make data security rules, and then you made data protection rules. So are these even the question of, is it ultra virus? 43A is a foundational question. But on a practical level, most companies try and comply with this. It has kind of bare bones requirements all around consent, collection limitation, use and disclosure, retention, security, many of the things that we talked about. But I think the weakest part of this, apart from the fact that it basically allows you to say, it basically allows you to have a really wide purpose for collection. So you could say, I need your data because I need your data. I'm oversimplifying. And that could pass off in this law, the way it's drafted. I think the big challenge, and this is important because of what we want to build, right? Like we need to know what's broken in order to fix it in this new law. I think the thing that's also really broken in the IT Act is the enforcement model. Essentially, there's no real meaningful way as an individual to those questions right now to say, even if under the current kind of weak protections we have, if we found out that somebody was misusing data and not using it according to their terms of use, what could we do under it? The IT Act actually has civil and criminal penalties for misuse, but it's not clear how a person actually approaches any authority in order to press for this misuse. So I guess the little tidbit of information that might be interesting is that it's not clear, first of all, what should you do in case your data is breached. We found that essentially the government needs to notify somebody as being the authority that can take your complaint. Several governments just never notified any authority for some years after the rules were put in place. And then I think at the level of the state, the secretary the state level secretary who is in the IAS, of course, can then take complaints from a person when they have charge of IT affairs. So essentially what you would need to do is find out the person in your state government who is a secretary in charge of these kind of things, and then you need to write to them. And then they would need to figure out what's the best way of helping you. Now, obviously, for most of us, so this is kind of like a strange procedure to have, and therefore it's very hard to even find out if many of these cases have been reached. The good thing is some people have taken this route. So essentially, it's not a great enforcement model as well. But I think the good thing is we have this new bill. What I'm going to do now is kind of quickly just share with you the bill itself. As I said, what we were hoping to do in this session is actually take you a little bit through the bill. Give me one moment. But in the absence of time, what I would like to do, is beam up the bill. Great. Can you all see this? I think you can. Yeah. So this is the bill itself, actually, bill number 373 of 2019. And in the next sort of 5-10 minutes, what I can do is just give you an overview of the structure of this bill, the key things to look out for, and maybe we can go quickly into some of the basic definitions, as it were, in this bill. The structure is quite, it's on par with many international data protection legislations. you have the definitions up front. You then have obligations for a data fiduciary. Now, this is an important definition, so maybe we can go through as we're speaking. What is a data fiduciary? This is a term many of you might have noticed if you've followed the discussions this week. The idea is that you construct the relationship between a company or a person collecting information, personal information, and the person who is giving that information through a fiduciary relationship, legally speaking. So super interesting. And we could talk a lot more about this. What is a fiduciary relationship? It's one fundamentally based on trust, where we understand that one party is in a level, has a higher power in that relationship for various reasons than the other party. Often this is because of the level of knowledge of that party, or the state of vulnerableness that the other person is in relation to that party. And examples of fiduciary relationships are doctors, priests, lawyers, and other people with whom, say, a litigant, a patient, or someone who is going into a confessional is really in a very vulnerable position and often does not have the knowledge that the fiduciary does. And so there we say you should act in the best interests, obere mea fide, for those of you who remember law school. We should act in the best interest of that person. So the fiduciary, in a normal contractual relationship, you could just look out for your own interests and maximize that. But in a fiduciary relationship, you must place the interests of the other person who is in that relationship of trust with you ahead. So that's at the conceptual level. And there, as you can see, many of the things that we talked about, prohibition on processing of personal data, that sounds a bit bland. I'm looking at section 4 on my screen, if you can see it. That really says you must process it unless you have a grounds for processing, you shouldn't process data, which means unless you have said that you are processing the data under this rule or this part of the act, you have particular grounds on which you're seeking to process, you shouldn't, which is a big step change from what we have now, where you can process it pretty much without having any grounds. And then all of the stuff we talked about, right? Purpose limitation, which was a collection limitation principle, is on 5 and 6. Requirement for notice, which we also talked about. A requirement for data quality to be maintained, which is I put in the general principles bucket. So to say that, say again, I work in the financial kind of regulatory space, but if a credit bureau is having a credit score about me, they should have a credit score about me now, not a credit score about me 10 years ago, 5 years ago, 3 years ago. So ensuring that quality is right in the data. Retention, how long can you keep the data? How accountable are you when you're holding someone's data in terms of telling them that you have it, keeping it in a clear way, answering any requests, auditing your machines, and so on and so forth. Now, this is one of their 11 obligations is one of the kind of sad failures for me of this bill. Even though I think notice is important for everybody to be given. So I'm not the person who says you shouldn't know that your data is being collected. I do think that consent, for the reasons we discussed, isn't the best way to give providers permission to use data. Unfortunately, in this bill, under most circumstances, unless your government, which we're going to come into, as a private sector provider, really most of the time you have to get explicit consent to process data. I don't know what this will look like in practice, and Neha will answer that. It could be that we're suddenly hit with a whole set of notices, basically. We could all be facing severe consent fatigue, but I'm sure there's some clever ways that other lawyers and companies are thinking about how to take consent, since that's the primary way that you can process data in this new law. So I went a little bit into deep dive there because I think chapter 2 nicely lines up with some of the conceptual framework principles we were talking about. Then we go into 3 grounds. So this is the kind of menu. So when you're deciding to take someone's data under this new law, you need to have a clear ground. You need to ask for consent. And if you don't want to ask for consent, you must have a ground, which is there in chapter 3, before you can access that information. I'm not going to touch on 4, but as we said, data of special processing, the 6th thing we were talking about, for children, we have a slightly different set of rules. And now, so the beginning part of this is really about principles of data protection. What are the obligations on a fiduciary? The second part is we go into chapter 5, and there are about 10 or 11, 12, 13 of these, 14 of these chapters. Clearly, I'm not paying enough attention. But chapter 5 is really very code because it shifts from duties into rights. And what are your rights? So as you can see there, you have four rights under this bill. Me and my organization think you should have more rights. Whether or not you choose to use them, if there is at least like a 0.1% of the population that cares and is able to understand. And I think more and more in India, we are seeing people really care about information. Like they really care about their privacy. And I didn't expect this, 5 years ago, the kind of quality of discussion and interest we see. So how do we get, how do we empower people to have rights, to confirm that their data is there, to access it, to audit their own data, to correct wrong information about themselves, to move their information around? And this very interesting right around when can you ask somebody to remove data that they have about you from their systems? And that's an interesting one, because I think what the section here is trying to do is trade off your right against the right of the party to have it, the fiduciary to have it, and anybody else who your data is recorded with. So say you're in a database which says, like the census, which helps us get a distribution of the population. If a set number of people decide they don't want to be there anymore, that might affect the entire database. That's actually less of a good example because the research is under an exemption. But a classic example is if you have your photo with somebody else and you want to take it off Twitter or Facebook, what should Twitter do? Because that somebody else is also in that photo, right? So whose rights, for instance, is one of those questions there. And then they have things that you need to do in order to exercise rights. And one thing I will say here, especially as a consumer advocate, as I see myself, is that this bill does a very clever thing of giving you rights, but then placing many barriers for you to use them, which I take serious issue with. It should be as easy to exercise rights as it is to access digital services, right? Like if I can download an app, why do I need and like use it? Why do I need to fill out a written request, pay a fee, and submit a request in order to exercise a right? And that's what this requires under 21 in this bill. There should be an easy way for me when I'm using my app to confirm if you have my data, to correct my data and so on. I think really it's a question of will, but there are some general conditions which, in my view, act as a barrier for exercise of rights. So that's the first section, and that's really what I wanted to drill down on. The remainder of this bill really goes back. So on the one hand, you have obligations of data fiduciaries, you have rights of data principals, and then you have some certain definitions that are framed. The chapter 6, 7 and 8, and grounds, of course. So the three things I would really take away are: one, from now on, you need to have certain grounds before you can access data, either consent or certain grounds in this law. When you access data as a data fiduciary, you must have your certain obligations. And then as a data principal, you have certain rights. The rest of this is very interesting because it drills down into obligations. Chapter 6 really says, what are the specific obligations, fleshes out aspects of those high-level purpose limitation type obligations. Say if we say we have an obligation to maintain good security safeguard says exactly what that is. It says that you need to report a data breach, for instance. So it really makes it more granular. There's chapter 7 looks at cross-border flows of data, which Neha will talk about tomorrow. And this gets really interesting, right? Because from 8 onwards, you really think about what are the exceptions to this law. So we've set up a construct. The story I've told you is that you have to have grounds to access data under this law. You have to have certain obligations when you're to respect the individual, and then the individual has certain rights. But very cleverly, the law then offers exemptions from the law. And this is normal. In many laws, you exempt, say, research institutions or small entities who are not very connected or maybe have manual data processing, or for innovations that certain types of rules will not apply. Interestingly, this law has a huge exemption for government use of data. Section 35 has been widely discussed in the data protection community in India, and a deep concern that essentially, please do go and have a look at the text of the section. I worry a lot that government is giving itself the power to exempt itself from this bill entirely through executive orders. So let's see how that plays out. And then this last part, and from here on, really we're going into the institutional mechanisms. We're stepping out of the conceptual principles and substantive law into the institutional mechanisms and the penalties and procedures to implement the law. So under this law, we will have a new data protection authority, and we have some detail about how that authority will work, where it will have offices, what are its powers, what is its relationship with the central government. And then, of course, as I'm scrolling down, you see 10 and 10, and also I think there you have 13. This tells you all the civil and criminal penalties that are civil and criminal offenses and penalties that exist in this law. It's nicely, the good thing is we do have some kind of complaints procedure. I would love to see it more user friendly, like I said, but where can you complain? How can you appeal a decision of the Data Protection Authority? How will it function? That's all covered over here. And then, of course, lastly, you have a set of provisions which are generally miscellaneous provisions about how do you make rules, how do you give them the force of law, and are there any overriding principles? Again, I think there are some really interesting bits of substantive provisions snuck away into these sections. We could have many sessions about this. But for instance, something that's a big point of conversation in India currently is section 91 and 92. 91, interestingly, is that second objective we talked about in data protection laws of ensuring enabling secure, fair digital flows for the economy as well. This provision previously said, the government is not stopped because of this bill from having other laws that enable digital flows. What they've done now in the most recent kind of change, the draftsmen of this law, or draft people of this law, is they've also said that government can access non-personal data and ask for such data sets to be handed over. That's very interesting because non-personal data as a term is not something that is well understood jurisprudentially. It seems to be a new kind of term that's popping up in one or two jurisdictions. I think only the EU has some case law around this, and maybe one instrument, but in India, it's kind of almost sui generis. So what is non-personal data? It's not necessarily defined. How should we make sense of it? And can government use a personal data protection law to make substantive rules around non-personal data and how it's used? So that's kind of a flavor. I've kind of taken you through a very quick canter through the kind of 14 chapters of this law. I wish we had more time, but I think I've kind of used the 15 minutes that Ananth had given me. I'm happy to take about 5 minutes of questions, Ananth, if you think anyone has some, or what would you like to do in terms of?
There are a few questions. So I have shortlisted a few because we don't have time for all of them. So can I just begin with a question by P. Vaishnavi Narayani, who wants to know whether a combined reading of sections 4, 5 and 35 of this PDP bill gives more blanket rights to the state, paving way for an Orwellian state.
4, 5 and 35. I have seen that quote in an Indian Express article in September. Am I right? Yeah, I know who started this. One of the greatest legal minds this country's had, of course. So I'm not quite sure. So with 4 and 5, this is to do with fair and reasonable processing. So I'm not quite sure of the link there.
But
I think
35 is from.
Yeah. So just to quickly answer the question, I think 4 and 5 is actually fantastic. I wish, I would have liked to see what is currently in 5, this obligation to process data in a fair and reasonable manner, be a standalone clause. One thing that I'll kind of reach out to you more about, Ananth, to tell this community is we want to build an interactive website tool at Dvara Research, where I am, the Future of Finance Initiative, to go through the various provisions. So we'll have that in the next couple of weeks. So you can check that out. But yeah, I think 4 and 5 are good because they have obligations to do fair and reasonable processing. 35 is worrying. As I said, yeah, I think we've kind of got our response out to Parliament. At the highest level, I think the old version of the security of the state exemption was better, and we should probably have some judicial oversight whenever state exemptions are claimed. But I think, I'm still hopeful, if all of us don't want an Orwellian state, can we do something to prevent it from happening?
Right. Mohit Chaudhary has a very interesting question. Given the fluid nature of data, is it even sensible or possible to have distinct regimes for personal and non-personal data? This is in light of the fact that anonymized data sets can still be linked back to individuals by linking it to other data sets in the public domain.
Yeah, that's a great question. And yeah, we've considered it and wrote a piece on the contours of how you should regulate non-personal data that's out there in the internet. So I agree. The idea that you're talking about is one called mixed data sets. There was an EU case about this last year, I think. So the general view in the EU that seems to be developing, and obviously they're very data protection friendly, so not to say that would be taken in India at all, is that if personal data is fundamentally interlinked with anonymized or other non-personal data, then it's mixed data sets and a personal data protection regime obligations would apply. So that's true. But however, I still think there could be a case where you have data that just has no personal information and never did. So I like to think about it in terms of anonymized data, which was previously human data, human beings data, and then data which was just never, which was non-human data. So say something from a supply chain, which is just a set of information about, how quickly, say, coal is moving from one direction to another direction on this train, which has nothing to do with any people on the train and so on. That's just a data set which is potentially could have anonymized information because it has trade IP protection. And I think there the kind of objectives that would apply when you're coming up, or the conceptual questions would be more around competition and trade and finance and those kind of corporate affairs, as opposed to privacy.
Malavika, I know you have a hard stop at 7:15, so just one last question. Kaiff Siddiqui has asked, and a lot of others too, these data principles have originated in the 70s and the 80s. Is there a chance of rapid advancement of technology making them a little outdated? And similarly, there are many other questions on the impact of data protection on innovation. So your final thoughts on that before we close.
Yeah. So it's interesting. I think, firstly, I feel like I'm not a believer in this trade-off between privacy and innovation, and data protection and innovation.
Yeah.
I actually think that it's a false binary that certain interests like to create, because it's a little bit lazy thinking, if you ask me. Like it's like saying, is there a trade-off between life and business? Like, no, we're living through that in the crisis.
Yeah, we are.
So you need to. So I think, I mean, it's a question of which values you want to protect in society. And I actually think the future is going to be, because if you keep harming privacy interests, people might retreat from certain services. That's one vision of the future. Or people might submit to them for the moment, but you'll have a lot of dysfunction. So very quick example, for instance, people might start mimicking behavior that they know that the algorithm or the system sees as good. Now, this is questions for conformism, but it also means people are not being trustworthy. So one issue that we've seen, like in the US, for instance, you have groups that get together to think about, how can I improve my credit score? By what kind of behaviors? Which is good. If it's working well, then they're saying, okay, I'm going to start paying my bills and XYZ. But say they realize that buying, Nike rather than Converse shoes puts you in the good camp, you start doing that. So really, people could start gaming the system, and one algorithm to fight another algorithm. So I think actually data protection becomes even more important in when you come to innovation. I think the broader point around, is it outdated? I mean, I actually find this really interesting when people ask me, will the law keep up? Because I think the law is a technology itself. It evolves. I think in fact, most of our most timeless principles are from times predating written law, right? Like the UK operates without a written constitution, and they seem to be doing okay, not in the current circumstances, but more broadly. So I think the principles are timeless. I agree with you. Like outdated laws, we are in serious need of change of certain laws. But I think the 70s is actually quite recent. We are in a country, mind you, where we're using a law passed in the 1890s to deal with a pandemic. So I think these principles are actually quite new age, and I don't think that they are cracking under the weight of technology. That's just my personal view. I think they're actually quite timeless.
Thanks, Malavika. I mean, there are many more questions, but we have to stop at some point because of time constraints. But thank you very much for laying down these introductory concepts and principles. And as I mentioned, tomorrow we have a follow-up masterclass by Neha Chowdhury of Ikigai Law, and she will be addressing many more of these practical issues on compliances, penalties, and of course, the elephant in the room, data localization. So on that note, thank you again, everyone who's participated. in this masterclass. And of course, do check out our website, www.dakshafellowship.org. We are in the second round of admissions, and we have 100% tuition waivers going through till the end of second round. So apply soon before we close the second round on 25th May. And do come back again tomorrow to check out the next masterclass. Thank you all again, and thank you, Malavika. This has been a fantastic lesson for all of us on introduction to data protection, and I'm sure that everyone benefited from this lesson. And of course, we hope to see you later this year at the Daksha Fellowship, teaching the course on data protection as visiting faculty at Daksha. Thank you very much.
Thank you for the opportunity, and thanks for everyone for making this. Thanks a lot, and have a nice evening as well.
You too.
Okay, bye.
Bye.